Well, everybody, it is now time to start the conference. How do you do? Welcome to session 2, the Western Hemisphere session. We've earlier held the Eastern Hemisphere session, which had different speakers. That took place yesterday. A recording of this will be available on the IBQC website. I'm chairman of the International Building Quality Centre and founder of Lovegrove and Cotton Construction and Planning Lawyers. The IBQC is an altruistic, multinational, international thought leadership hub that develops international best practice building regulatory policy guidelines. Our board comprises internationally renowned legal experts and law reformers. If you haven't familiarized yourself with the IBQC website, I encourage you to do so and to have particular regard to our guidelines library. The conference will address ways to improve affordability and accessibility to construction dispute resolution for industry, government, and the global citizen. To reduce the risk of technical problems today, we ask that participants turn their cameras off, as we've been informed that an overload could disrupt the stream. All attendees will also be muted to avoid disruptions, and the questions should be directed to the Zoom chat feature. The questions will be addressed at the end during the panel session. The speakers are, in a word, preeminent, ranging from senior jurists to KCs to law reformers and economists of international renown. Each speaker will be presenting for 10 minutes. The conference is recorded and available for viewing after the conference conclusion. The PowerPoints will be published on the IBQC website, along with the recording. The IBQC and the International Codes Council are the hosts, and the Society of Construction Law in New Zealand is a co-sponsor. Now, it is my great pleasure to introduce Her Honour Judge Gloria Kalebi-Namond and Gladys Gondwe. Her Honour Gloria Kalebi-Namond is a judge in the Commercial Division in the High Court of Malawi. Her Honour Justice Gladys Gondwe is also a High Court judge in Malawi. Together, they're speaking on the topic of an overview of the law addressing construction disputes in Malawi, the pros and cons. Thank you.
Thank you so much, Kim. And thank you, everyone. As Kim has said, we are speaking on an overview of construction disputes resolution in Malawi, the best practices for cost reduction. Let me start by saying that I think the conference is coming at the right time, especially for us in Malawi. And we stand to benefit greatly because I think our jurisprudence in the sector is developing. It's in its baby steps. So we are looking forward to gaining more insights through this conference. To contextualize where Malawi is at the moment, we are a developing country and as well as a small economy. But at the same time, we have our own aspirations, which we want to achieve by the year 2063. And these have been reduced in writing through the Malawi 2063 agenda. This is our official document as well as a roadmap. And it details how, as a country, we intend to become a self-reliant nation, and also as well as being very inclusive, to have a minimum per capita income of about $4,000. And we want also to fund our own development needs. Next slide, Cameron. The agenda has about 10 goals, but I think of interest to the discussion at hand, we have about 3 of those goals, which tying very well to this conference. I think that's why we are very excited to be part of these deliberations. So we are saying we want to have a vibrant, knowledge-based economy with robust, competitive manufacturing industry. And this is to be driven by a productive and commercially vibrant agriculture and mining sector. We also want to have world-class urban centers and tourist hubs across the country with requisite socioeconomic amenities for a high-quality life. We believe by having this goal, we would also attract tourists to come to Malawi to see interesting areas and places that we have in Malawi, and thereby growing the economy of our country. At the same time, we also want to have a globally competitive economic infrastructure. So to achieve these goals or national aspirations, it is a given, you see, that we need to have a good road, railway network, and even as well as other physical infrastructures. As such, presently, if you come to Malawi, you find there are noticeable developments going on. We have renovation of roads. Most notable is what we call the M1 road. The M is main road. This is a road that connects different regions in Malawi and all districts. So this is currently being rehabilitated. We are also having renovation of different railways to connect us to our bordering countries. Malawi is a landlocked, so we rely on countries like Mozambique, Tanzania to have goods that we are importing through the sea. And then to have a railway, it's cheaper than to use the road network. At the same time, we are also, the government is constructing a number of schools in different districts, teachers training schools, hospitals, court buildings. And now inevitably you will see that disputes are bound to arise as we develop our country. Before the court, I would say that even before my court, I have had a number of disputes, cases. I will give examples as we go along with the presentation, just to show that Malawi is not immune to having disputes in the construction sector. What we have noted is that the causes of the disputes range. We have maybe delays caused by different factors, perhaps maybe payments, disagreements to modified and amended plans, and even professional negligence. And these disputes, if not addressed or resolved, we have noted that there are other projects that have been delayed. Some projects have halted. The good part, though, is that for those cases that have come to the courts, I would say that they are going on, or others have been completed, pending maybe the full disposal of the cases. And at the same time, I think it is not an option for Malawi to have so many disputes, because as we are talking today, we want to reduce costs. And these disputes, if the costs are incurred, for Malawi being a small economy, we do not have that luxury, because we want each and every penny to be utilized for the benefit of the people. The law in Malawi has provided for a number of avenues for dispute resolution mechanisms. Construction disputes, not being an exception, they are also subjected to the same laws. So the primary one, of course, I know as in many countries, is our constitution. Then we have the Courts Act, which is the enabling law, at least in as far as the courts are concerned. We have the National Construction Industry Act. We have the Arbitration Act. And then we have the High Court Civil Procedure Rules. So the Constitution is giving the High Court of Malawi the unlimited original jurisdiction. So virtually, the High Court can preside over any matter under the sun, construction disputes being one of them. And then the Courts Act has created different divisions within the High Court with different specialties. I belong to the commercial division, which construction disputes being commercial in nature will be coming to. The advantage of having this commercial court division is that the cases are supposed to be handled with speed. At the same time, once one has subjected themselves to the jurisdiction of the court, then the rules, the courts, the ones that I've referred to, which are a creation of 2017, they give a judge a very wide and discretionary powers in how a case that comes before him or her is to be resolved. So at each and every point, when a case is before you, the overriding objectives of these rules needs to be exercising in the judge's mind. So the judge will need to ensure that the parties are on an equal footing, we are saving expenses, and then dealing with the proceedings in ways that are proportionate to the amount of money involved in a particular dispute. You also need to have in mind the importance of the proceeding, complexity of the issues, as well as ensuring that a proceeding is dealt with expeditiously and fairly. So already you begin to see that the rules then are addressing our question of cost reduction. Again, at the same time, a judge is invited to actively manage the cases before her or him. So we have to encourage the parties to cooperate with each other in the conduct of proceedings. Again, if the matter is before you, need to identify the issues that can be resolved at an early stage. If it's the whole dispute, well and good. If not, then you need to decide promptly which issues will need full investigation and a trial, and which issues can be disposed of summarily. Again, the judge is also called to encourage the parties to use an alternative dispute resolution procedure if the court considers it appropriate, and facilitating the use of such procedure. A case comes to mind where I also encouraged parties. I referred the parties that came before me for a dispute, I think regarding payment of the performance security guarantee. And one of the parties, the claimant in that matter, had obtained an injunction, which I vacated, and I encouraged the parties to go for arbitration, and he gave a time period of 60 days so that they can come back to court and address or update the court on how the arbitration has gone on. So we also fix timetables, or indeed control the progress of a proceeding. Again, another case comes to mind where a contractor sought an injunction against government, and then you consider, because this contractor was building a home-based care in one of the rural areas in Malawi, in the northern part of Malawi, and wanted to get an injunction to restrain the government terminating the contract. But this was a contractor that was taking forever to conclude building the home-based care, which was needed for toddlers in that area. So the injunction was not granted, and we allowed the government to proceed. But I also gave a time period of 21 days within which the parties were to conclude their discussions and again to come back and update the court. Again, I think when in doing that, so you have a number of factors exercising in your mind. In doing that, I was also considering the benefits of taking a particular step if it justifies the cost of taking it. We are also called to deal with as many aspects of the proceeding as the court can do on the same occasion or on one sitting. Making use of technology, having maybe hearing matters virtually. I have done this once in a construction dispute where one of the parties was outside the jurisdiction, and it was a mediation. Unfortunately, as you see, it's also another mechanism that I'll be highlighting. It has its pros and cons if you're going to use technology in mediation.
Your Honor, if I could interrupt, we've got 9
Yes.
speakers and we're starting to run a little bit over, and possibly some of the matters could be dealt with in question time. I'm just
Yes.
mindful of the fact we've got 9 speakers and a 2-hour allocation.
Okay. All right. How long do I have to go? How many minutes?
Actually, you're over the 10 minutes already, Your Honor.
Okay. Let me conclude then.
Yes, thank you.
So we have the mandatory mediation. So that one is under the rules, and it's not also not optional. Here the judge will be taking off the judicial hat and wearing that of the mediator. So the advantages is that if matters get resolved at mediation, obviously parties will go in a conciliatory mode, relationships not damaged, costs are reduced. Another mechanism, I think I would say it's injunctions, where parties will come to court. I think the examples are the ones that I've given, where parties want to restrain either a contractor, a main contractor, employer, or government not to terminate a contract or not to pay the performance security guarantee as well as the advance payment guarantee. So it is also up to the court weighing those principles on whether to grant the injunction or not to grant the injunction. So we also have the arbitration avenue. The arbitration avenue is provided for under the Arbitration Act, as well as the National Construction Industry Act. Sufficing to say that the main objective or the principle behind it is that the disputes need to be resolved promptly without wasting a lot of resources, financial resources. To conclude, Kim, from the case statistics, which have not confirmed, we do not have a lot of construction disputes in the courts, possibly because many parties are resolving the disputes by themselves, or they are opting for the arbitration avenue. But it is suggestive that if we have key clauses within a contract that are well couched, we automatically reduce disputes, and in turn, we reduce costs in construction disputes. Thank you, Kim. Thank you, everyone.
Thank you very much, Your Honour. That was most informative. Now, the next speaker is Together de Lovegrove of Lovegrove and Cotton, Ethiopian-born and practicing law in Australia. Her topic is the development of contextualised front-end mediation mechanisms to facilitate more cost-effective access to construction dispute resolution in the Horn of Africa. I reiterate, it's critical that Together that you give the talk well inside the 10 minutes. Thank you.
You might be on mute.
Thank you, Neil. Thank you, Kim, and thank you also, Your Honour. That was very informative. Now, my topic is mediation. Mediation is a facilitative process in which parties in dispute come together to discuss and reach an outcome or resolve their dispute with the assistance of an impartial third party or a mediator. The role of the mediator is to help the parties negotiate an agreed resolution of their dispute. Unlike adjudicators, mediators cannot impose judgment or make any decisions that are binding on the parties. Instead, they apply their skills to assist the parties negotiate an agreed outcome without an outcome being forced upon them by a court or a tribunal decision maker. Next, please. Compulsory mediation is critical to construction dispute resolution in an emerging economy. At this conference, you will hear that the cost of construction dispute resolution is very, very high everywhere. Even in developed economies, consumers find it very challenging to fund the cost of adversarial dispute resolution. In emerging economies, the cost imposition is both prohibitive and unsustainable, as in some emerging economies, poverty is widespread and the majority of the population survive on a subsistence economy basis. They simply cannot afford to spend their very finite financial resources on construction dispute resolution. And as consumers, they are incredibly vulnerable. And in reality, they are denied access to conventional judicial machinery. It follows that adversarial dispute resolution, that is part of the DNA of traditional adversarial dispute resolution, is simply not compatible for either the Horn of Africa, where I come from, in many other emerging economies. A contextualized best practice approach that is sustainable for the boots on the ground reality of emerging economies is mandatory front-end mediation. The state can afford to license and accredit trained mediators and to make them accessible to disputants. Next slide, please. But unlike some Western jurisdictions like Victoria, where I reside and practice construction law, where the state underwrites the cost of the mediation apparatus, in many African countries, the state will not be able to afford or underwrite the function. It follows that the disputants will jointly remunerate the mediator, and as most building disputes ultimately settle at mediation, mediation will occur before legal proceedings can be issued in a court of law or tribunal. Compulsory conciliation as a prerequisite to litigation is compulsory by law in the Australian state of Victoria. There is free mandatory domestic building resolution process facilitated by the Domestic Building Dispute Resolution Victoria, or DBDRV, where parties to domestic or construction building disputes are first assisted by nationally accredited dispute resolution officers who will facilitate the conciliation and assist the parties to come up with ways to resolve their dispute. If the matter is not suitable for conciliation, then parties will receive a certificate of conciliation and they may commence proceedings in a court or tribunal of competent jurisdiction. Thus, I submit that there should be a best practice model accredited system, as you can see on the screen. Now, the aim or purpose will be to promote quality, consistency, and accountability of accredited mediators under such system, as well as to improve the protection of consumers of building works. Now, this is an example, what you see on the screen. So the suggestion is that there should be the mediator standard board, which oversees the system. It should be a register, so the register of accredited mediators, and this register should be accessible to the public. Say, for example, if a member of the public want to engage a mediator, they should be able to go look it up on the internet, I suppose, and see whether the mediator that they wish to engage is accredited or not. We then have the approved standards, which specify the training, assessment, personal qualities, and experience required of an accredited mediator. Then practice standards, which specify the minimum practice and competency requirements of an accredited mediator. This may include the practice standards, may specify the minimum practice and competency requirements of an accredited mediator under the system, the knowledge, skill, and ethical principles required of an accredited mediator, and matters that an accredited mediator must adhere to, such as procedural fairness, impartiality, ethical conduct, and professional relations, and so forth. I also submit that there should be a recognized mediator accreditation board, which accredits mediators under that system. These accredited bodies must have financial membership with the board and have the capacity and expertise to assess whether applicants for accreditation or renewal of accreditation meet the respective requirements specified in the approval standards. Thank you.
Thank you. Very good. That was very good, Segerda. Moving on quickly. Our next speaker is Rachel K. Comic partner, the venerated American law firm Morgan Lewis and Bockius. Rachel practices in complex commercial and class action litigation in the United States. Her topic is on the pros and cons of arbitration in the United States. Thank you, Rachel.
Well, good afternoon. I am happy to join you all today from Washington, D.C. You can jump onto the next slide past my face and bio since I'm up at the top of the screen. Thank you. Okay, so I'm a litigation partner at Morgan Lewis, and I've been privileged to represent the International Code Council. And I want to talk today, following that excellent presentation on non-binding mediation, about binding arbitration. And given that this is a global conference, I think I want to start by noting that in the United States, we have federal and state courts and federal and state law. And we have significantly developed U.S. federal law that encourages arbitration proceedings, dating back to the 1920s in the U.S. Key here, we have the U.S. Federal Arbitration Act, which reflects a liberal federal policy favoring arbitration agreements. Because we have a federal system and the FAA is federal law, it preempts any contrary state law. And it provides, I think probably in most significant part, that arbitration agreements shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. In practice, this means that courts, both federal and state courts in the United States, generally enforce arbitration agreements, and many putative actions are compelled to arbitration or simply brought there in the first instance. Next slide, please. So because arbitration is common and frankly popular in the United States, there are a range of arbitration providers that entities can choose to use when they have an arbitration. that you have AAA, the American Arbitration Association, and JAMS, and ADR Services Incorporated are just some examples. Now, AAA publishes some of its own statistics, and I think it's notable here today that they say they've resolved more than 10,000 cases and nearly $15 million of claims in 2022 alone. Next slide, please. And there are many positives to arbitration that I think are relevant here in this conference. Arbitrations are typically much faster than litigation. And I guess the AAA has estimated that on average, U.S. district court cases took a year longer to resolve than matters resolved by arbitration. There are shortened discovery times and simplified procedures. Next slide. And arbitration is also typically, although not always, but typically cost effective. The proceedings are often, as I said, shorter, they're less complicated. Discovery tends to be limited. Motions practice tends to be limited, and that saves the parties on attorney's fees. Additionally, you can usually customize an arbitration with the arbitrator to suit your specific budget and needs. And additionally, because we're talking about binding arbitration, but it's outside of the court system, usually when you get a binding arbitration award, that avoids any appellate process, which can also keep things cost effective. Next slide. That said, it's always worth noting that, especially in the US, it is the case that arbitration costs can be rising. It's not always cheaper than litigation to arbitrate, and particularly in complex commercial cases, arbitration providers may provide significant administrative fees, and that can be true in the construction context as well. Parties are responsible both for the arbitrator provider's fees and for the arbitrator's hourly rate, which in the US can range from $300 to upwards of $1,300 American dollars an hour. And depending on the type of dispute, usually you only have one arbitrator, but you have cases that proceed with a 3-arbitrator panel, which can increase some costs. And, you know, it really, because it's arbitration rather than in court where we have quite set procedures, it's flexible, but depending on the type of dispute, you can have numerous depositions. You could have even third-party depositions. You could have interrogatories. Sometimes you have significant document productions, and you can have motions practice. I think you could have motions to dismiss. You could even have motions for summary judgment. And at the end, you would have a hearing prior to an award, and it could be a lengthy hearing depending on the matter. Next slide, please. And I'm not sure even that this particular point is as relevant in the construction context, but I think it's worth noting that we have seen a trend in the United States of what we're referring to as so-called mass arbitrations, where plaintiffs who agreed by contract to a class action waiver and to an arbitration provision there are plaintiffs' firms that are filing numerous claims on behalf of individual claimants in arbitration in an attempt to leverage what can be significant, if compiled, arbitration provider fees that are usually due at the outset of an arbitration to force settlement. Now, we don't really know where this trend is going to go. It's sort of a new thing, but I wanted to put it on your radar. But I mean, that being said, I think that especially in the US context, arbitration is a very important tool with respect to resolving construction disputes. Both AAA and JAMS, which are probably the most well-known of the US arbitration providers, offer specific rules and procedures for construction industry disputes. And I just think that's a really important point that can't be overstated in this context, because these are rules and procedures that are voluntary. You would opt into them, but if you select them, they've been specifically developed with the construction industry in mind. And so, you know, for example, AAA offers a range of different kinds of procedures that are just within the construction industry context. They have procedures for resolving disputes on the paper. They have specific fast track procedures for matters that are less than 100,000 US dollars. They have sort of like what we would call regular track procedures, and then another set of procedures for large matters that are where the amount in dispute is more than $1 million. And similarly, JAMS offers both standard and expedited procedures that are tailored to construction disputes, in binding arbitration. So depending on the track between these providers, you might have a preliminary hearing, some form of pre-hearing discovery, and then a formal hearing, depending on the prior to an award, unless you proceed on the papers. Next slide, please. And I think another particularly notable point is that these arbitration providers have panels of neutrals that are specifically well-versed in the construction industry. So, I mean, that's obviously a significant benefit if you're in a construction industry dispute. AAA, for example, maintains what they refer to as the National Construction Panel, where the majority of their arbitrators are actively involved in the construction industry, with more than half their time on construction-specific matters. And alternatively, sort of looping back to the prior presentation, JAMS offers what they call a panel of construction project neutrals who offer non-binding mediation services. And those services can help with a project from the beginning of the construction process, right from design through acceptance of the project on a non-binding basis, or you can move into more binding arbitration. Both AAA and JAMS offer, as reflected on the next slide, a specific fee schedule for construction-specific disputes. And I've simply pulled from AAA's website one aspect of one of their proposed fee schedules. I mean, excerpted it here simply to make the point, more than anything else, that is reflected on my conclusory slide. You know, the rules that would be involved and the specific procedures in the construction industry are publicly available. And I think that's perhaps even the most important point for the nature of this conference. AAA and JAMS construction rules, like all of their rules, are available on their website. So the details that have gone into what are very thorough procedures are available for your review and consideration as we think through, you know, the best methods for dispute resolution globally in the construction context. So I appreciate your time and the opportunity to speak with you, and I look forward to the discussion later on.
Thank you very much, Rachel. That was a power-packed and very comprehensive synopsis of the American arbitration system. Thank you so much. Now, Zama Nkobo is a senior South African construction lawyer and a board member at the IBQC. Zama's topic is challenges in emerging economies and how the IBQC guidelines serve as a guide for improving construction dispute resolution in Africa and other emerging regional economies. Zama also participated in the development of the IBQC good practice guidelines. Thank you, Zama.
Thank you for the introduction, Kim. Good evening, everyone. So as Kim has said, I'll be discussing the good practice guidelines for the development of construction, dispute resolution tribunals, and decision-making institutions. They were published by the IBQC in June 2022 and are available on the website. So the preface to the guidelines provides that building disputes are often costly and time-consuming. This cost and delay can add significantly to the stress associated with the building disputes and can sometimes result in there being insurmountable barriers to procuring independent resolution of disputes. Given these circumstances, those involved in building disputes can readily feel that justice and fairness is out of their reach. So these challenges can apply to all types of disputes, but the guideline is very specific in relation to what type of dispute it applies to. It specifically applies to disputes of modest value involving works of modest complexity with parties who are individuals or modest commercial entities. So it will be for each jurisdiction to then determine what exactly moderate or modest means, but these guidelines, just to clarify, are not appropriate for high-value complex projects, nor are they intended for use in cross-border transactions. The guidelines set out 9 principles, some of which are interlinked, so I won't be discussing all of them. I'll just be talking about some of them and their relevance in the South African context and also in the context of emerging economies. So the first principle is that dispute resolution mechanisms must be a public forum with legislative backing. The guidelines provide that this kind of forum will facilitate consistency in the way disputes are managed and will allow for mandatory adoption of practices. It also provides that proceedings should be in public and the reasons for the decision must be published. So if we bring it back to the South African context, there are 4 main standard form contracts that we use in the construction industry, which are approved by the Construction Industry Development Board, the CIDB. So these are the Joint Building Contracts Committee Suite of Contracts, the JBCC, the General Conditions of Contract for Construction Works, the GCC, FIDIC, as well as the NEC3, which I'm sure a lot of you are aware of. All of these contracts provide for similar dispute resolution mechanisms. So it's amicable settlements. JBCC and GCC provide for voluntary mediation, and then there's adjudication and arbitration. For the non-lawyers in the room, amicable settlement is when the parties, senior management of the parties of the project sit around the table and seek to resolve the dispute without third-party intervention. Mediation, as Ziggy has explained, is when you have a third party just helping to resolve the dispute. So a skilled mediator would then not strictly stick to the terms and conditions of the contract. They will seek to determine what is in the interest of the parties, what is in the interest of the project, what the concerns are, and seek to facilitate the parties reaching some form of common ground. So of course, if we resolved disputes through mediation, it would be cost effective and efficient, but mediation is not mandatory in South Africa. And at this stage, the main way we resolve disputes is via adjudication. So adjudication is an accelerated form of dispute resolution designed for summary and interim resolution of disputes. Adjudication allows for the parties to resolve the disputes during the lifetime of the project in an efficient and robust manner, so as not to impact the continuation of the works. If a party is not happy with an adjudicator's decision, they then go on arbitration. Now, arbitration is very common in South Africa and across Africa. But the problem with arbitration is that because it's a private hearing, the arbitrator's decisions are generally not published. So they don't contribute to the development of the body of construction law. The decisions don't carry a lot of weight in court proceedings. And as I've said, the law is not developing in any way. You could be in an arbitration on a point of law that was decided in another arbitration just a month prior, but you have no way of knowing this, and the law is not developed. As a result of this, adjudication and arbitration tribunals will generally rely on foreign law, in our case usually, and in the case of a lot of African countries, on English law, to fill in the gaps in our law. And as I've said, this doesn't help with the development of South African law. So a public forum would help develop a body of construction common law, which will in turn result in efficiency in project delivery. Not only would it facilitate the way in which disputes are managed, but can also encourage dispute avoidance. In particular, if a particular legal issue has been determined by the court and then an issue arises on site, the likelihood is that you are going to approach your attorney, who will then look at how that issue was dealt with by previous court judgments, and then advise you on, if you go to court, what will your prospects of success be? And that will help determine your strategy. Do you continue in an adversarial manner, or is it in your best interest to settle this dispute? So I do think a public forum will go a long way in creating efficiency from that perspective. One of the other principles is that dispute resolution should be simple, efficient, and relevant. The disputes contemplated in the guide, as I've said, are modest disputes, so we're not dealing with hectic amounts here. As I've mentioned, one of the standard form contracts we use is the JBCC. Now, the JBCC, the Joint Building Contracts Committee, is a South African entity comprising developers, employers, project managers, and they've come together to draft these standard form contracts. There's a few in the suits, but I'll just mention three. The principal building agreement, which is required for large property developments. Then there's the minor works agreement, which is for less technically complex and less expensive works. And then there's that simple works contract, which was published in 2020. So I just want you to think about modest when we talk about the simple works contracts. It's intended for alterations, renovations, and additions to existing buildings, new building works that are not more than 3 stories in height, where no sophisticated building systems are used, no complex services are to be installed. It's not suitable where the construction period is longer than 9 months or where the contract value exceeds 5 million. So it was interesting for me to note how the drafters of the JBCC acknowledged that when you're dealing with small disputes, you do need to step outside of the norm in terms of the terms and conditions which we generally see in FIDIC or the other terms that we use, and create something a little bit more bespoke that will create efficiency in that space. But they have not followed through, in my opinion, in that, because the dispute resolution procedures that apply to high value property developments also apply to the simple works. So they both have an almost identical dispute resolution clause, which provides for amicable settlement, voluntary mediation, adjudication, and then arbitration. And if you consider the fact that amicable settlements and mediation are not compulsory, then the primary point of dispute resolution is adjudication. And if you're not happy, followed by arbitration, which then is not suitable in the context of, for example, a renovation. So some of the ways the guideline proposes simplifying the resolution of modest disputes is through relaxing the rules relating to evidence, giving the tribunal full authority to determine the weight of any evidence that is provided, and also doing away with the discovery of documents. So construction disputes are notoriously document intensive, but if you're dealing with a modest project, it's usually much easier to crystallize the issues at hand. And so the exchange of documents process that we go through in discovery is not necessarily required. The main standard form contracts we use do have adjudication rules and procedures, and the arbitration rules we generally use will be dictated by the parties, but none of these are as prescriptive as the guidelines are. So the guidelines are very specific in that the parties' written submissions cannot, unless agreed by the tribunal, exceed 40 pages, excluding witness statements and annexures. And where the tribunal considers it appropriate, it will determine the matter on the papers alone without a hearing. But where there is a hearing, the parties will be allocated the same amount of time to present their case on a stop clock basis. So there definitely is, you can see the provisions that encourage swift finality of disputes. One of the other principles is that appeal procedures should be limited and protect the parties from abuse. So the guideline provides that the forum must allow for finality of disputes subject to limited appeal rights. Now, as I've mentioned, adjudication is the primary method of dispute resolution, and it's intended to be a fast-track dispute resolution mechanism that gives you a decision so the project can continue. But if you look at all of the standard form contracts, if you're not happy with an adjudicator's decision, all you have to do is submit a notice of dissatisfaction, and then you can proceed and go to arbitration. So the fact that it's that easy to just challenge an adjudicator's decision or attempt to challenge it, it's not necessarily that you'll get the order that you want, but it kind of defeats the purpose of a speedy resolution of disputes. So what the guidelines propose is that there be one level of appeal in the case of modest value disputes, and that an appeal can only be brought with leave from the superior tribunal or the courts. The guideline proposed that there should be limited grounds upon which a party can raise a dissatisfaction or an appeal to a lower tribunal. For example, the superior court or tribunal can only grant leave to appeal the initial decision if the initial decision is patently incorrect, or if the appeal tribunal or court is of the view that the appeal has real prospect of success. So I thought that was useful in terms of just encouraging the finality of dispute and not allowing parties to abuse the process of appeal or maintain dissatisfaction. Another principle I want to discuss is that the process should encourage and facilitate early settlement. So this is quite interesting because in traditional African systems of government and the traditional systems of government in Africa were open and inclusive, where people could participate in the decision-making process. Disputes were handled through traditional amicable settlement with emphasis on reconciliation and restoration of social harmony rather than on punishing conflicting parties or on rewarding individual rights. So conflict resolution in traditional African societies provided opportunity to interact with the parties concerned. It promotes consensus building, social bridge reconstructions, and enactment of order in society. African traditional mechanisms of conflict prevention, management, and resolution were largely effective because of the shame you would bring to your family if you did not comply with what was in the best interest of the community. So the guidelines are in some way promoting that we care a little bit more of the best interest of the project and the interest of the industry as a whole. Once we look at the processes that are in place are actually effective in the context of the disputes we're talking about here.
About 2 minutes to go, Emma.
Oh, thank you. So the guidelines propose moving away from an adversarial system of dispute resolution and placing more emphasis on what's in the best interest of the project, which is traditionally how we resolve disputes in African society in the pre-colonial era. So the guidelines require that the parties should be encouraged to settle the disputes at the earliest given opportunity, and that mediation should be compulsory unless there's a good reason why mediation cannot occur. So in South Africa, we do have mandatory court-based mediation, but yeah, it's mandatory that you engage in the process, but of course they can't force you to come to a resolution. And the problem with the courts in South Africa is that there's a lack of specialized construction law judges to hear the case. So that doesn't work either. And I think we definitely should interrogate the use of these guidelines a lot more. I think there's a lot of value in applying them in the South African context. I'm happy to end here, Kim.
Thank you very much, Zama. That was a very, very interesting paper, and I like the fact that you contextualized it with regards to some of the traditional ethos. And we can talk further about that in the panel session. Now, my friend Alfred Amenya, fellow board member. Alfred's a professor at University of Nairobi and CEO of EcoBuild and a board member of the IBQC. And he's presenting on the same topic, but coming from a different perspective. I'll just remind you, Alfred, we're going well in accordance with the time schedule. If you're kind enough to encapsulate your talk in 10 minutes. Thank you, my friend. Lovely seeing you again.
Thank you very much, Kim and the IBQC. Yes, I'm very happy to take part in this conversation about global construction dispute resolution. And improving accessibility, affordability, and specifically to discuss some of the challenges and I would say also opportunities in emerging economies. I'll be wearing more the hat of a practitioner, but I also interact quite a bit with these issues within the industry here in Kenya. I've been part of this in terms of projects that I've been involved in. I've also worked with quite a lot of communities, especially having disputes, with government on large infrastructure projects, road, water, electricity, and so on. And I've also taken part in a number of these processes as an expert witness. In fact, currently, one of our associates here in Africa is helping the Supreme Court in Kenya to develop. The Chief Justice of the Republic is particularly very, very strong in supporting. Yes, so basically we've seen a big push for alternative justice systems and the use of reconciliation, adjudication, and arbitration in a lot of the construction cases lately. And there are a number of reasons about that. These are, in fact, they've always been there in the standard form of contract in Kenya, JBCC. But they're also a major feature in the international contracts, the FIC, particularly promoted by World Bank, both in building construction projects, but also on civil works projects. These provisions for alternative justice system are normally entrenched in those contracts, and increasingly people are being encouraged, disputants are being encouraged to explore process, as has been highlighted by the speakers in Kenya, can take quite a long time. And in that way, then, of course, a fast-track process then is a lot more encouraged. Then there's always the issue that parties are never happy with the outcomes of litigation process. So there's a bit of that concern that communities get awards, and sometimes those are just ignored, and they keep going to court and getting appeals and so on. And because of the time that this takes, then you end up with a very, very long. So of course, I mean, a lot of the construction disputes in Kenya just go through normal litigation, and that is actually governed by the Constitution and the civil procedure that spells out the processes, spells out evidence, spells out issues around witnesses, spells out when these procedures can start, spells out the process of defending the claims and so on. Yeah, so all those the system is there, like we said, coming all the way from the High Court all the way to the small claim courts, and that's very, very clearly elaborated in law. But then, on the other hand, the alternative dispute resolution in Kenya, I would say, is in between. we actually have some provisions for some particular types of processes, and others are not necessarily supported by law. We, for example, have conciliation processes, and the only part of Kenyan law that supports that is basically Employment Act, and is basically not used in construction disputes. Then we have mediation, and as I said, most construction contracts actually do recognize mediation and exactly put in there within the contract, and there are guidelines from High Court in terms of how to proceed with mediation, and it is sort of considered to be a lower level dispute resolution system, partly because of the non-binding nature and the fact that some of these can actually be contested in a court of law. Arbitration is the most common, actually, and we do have the Arbitration Act of 1995, and it allows the disputants to refer their cases to third parties, and also makes provisions in terms of procedures, in terms of the principles, in terms of timelines and expeditious ways of dealing with this, in terms of cost, and in terms of the binding nature of those particular outcomes. Of course, when parties are not very happy with the arbitration process, normally they would end up in litigation. But currently, there's a lot of work being done by both government and international agencies to sort of build capacity, both of professionals and communities, so that they can take part effectively in arbitration processes. And the Chartered Institute of Arbitrators, the Institute of Engineers of Kenya, the Architectural Association of Kenya, where I sit, actually do have active training of our members on arbitration process, because we see it as one of the best ways of accessing justice in construction disputes. We also actually have traditional dispute mechanisms where individuals are able to get into sort of informal arrangements with third parties that they're actually that is supported by the Constitution. Then, of course, we do have adjudication that again is organized and coordinated by the Chartered Institute of Arbitrators. They're very, very active, and they do recruit members from different construction industries, and then they're able to sort out these disputes. And of course, there are provisions in Kenyan law that allows for tribunals to be established and that aspect of adjudication. And as you said, this is actually an emerging area, the alternative dispute resolution, and is entrenched actually in the new Kenyan Constitution, Chapter 8 of the laws of Kenya, and quite a bit of the methodologies and how to go about it is actually have actually been made available. And then we also have mediation rules that have been developed by the courts in terms of practice. But as it were, I mean, of course, just like the South African case, we need a lot more of development of guidelines and even broader jurisprudence. But as it were, I think from the courts in Kenya to the practitioners, it is very, very clear that the alternative justice system is a way to go, and these other mechanisms that have been provided in there, be it low, what is actually being supported as opposed to litigation, because we don't even have the capacity to continue, with these particular processes within the court system. The cases are too many, and even the small claims court that moves pretty fast, the cases are very, very many. So you go in there, and most likely you'll be spending 5 years, dealing with a small matter that could have been dealt with, through the support of these alternative mechanisms. So thank you very much, Kim. And
thank you, my friend.
IBQC. I think this is a timely conversation. Sorry for the network issue.
there's always going to be some sort of IT malfunction. And we got the gist of what you were saying. Again, it's a very good cross-cultural perspective. And I'll tie some of your threads together at the end of the talk. Now, it's my great pleasure to announce the next speaker, Eligio Espinosa Wang, Senior Private Sector Specialist at the World Bank. Eligio and I did a tremendous amount of work until COVID. We were regularly retained at the behest of the World Bank to advise reforming jurisdictions in China, in fact, 4 governments on international best practice to do with building regulation. And part of that gamut was looking at best practice dispute resolutions to bring systems to bring better efficiencies and cost effectiveness to dispute resolution. Now, we've heard a lot from venerable lawyers, but Eligio's topic is very important. Why better access to justice in the construction dispute resolution sector is an economic imperative for emerging economies, an economist perspective. And I might add that Eligio is now currently domiciled in Addis Ababa and will be for another 3.5 years. Lovely seeing you, my friend. Looking forward to your talk.
Thank you, Kim. Thank you very much. And very good afternoon, good night, or good morning, wherever you are listening to it and watching us today. So first of all, I want to say that the views I'm going to express today are my own. They're based on my work experience, but are personal views. And that I will try to convey a message on the importance on conflict resolution mechanisms from an economic perspective in the emerging economies. And the first thing we should talk about is why, no? Why do we need efficient conflict resolution systems? And this is something we have worked with Kim in other projects, and we put together this kind of framework where we see that a holistic building control system is key to ensure safety standards that protect the public while making the permitting process efficient, transparent, and affordable. And as you can see, there are many parts of this building control holistic system. There is central government regulators. I'm not going to go over all of them, but you can see some of them: risk-based building code and building classifications, effective licensing and property regime, liability and accountability indemnification systems, and of course, conflict resolution systems. So this is why it's important to have this in mind, because it's key for a healthy building construction system. Next slide, please. And one of the challenges when preparing for this interesting discussion is that there's very little data on the construction sector and the mechanisms to dispute mechanisms. So I did my best. I looked around. Probably if some of you have better data sources, we can discuss that some other time. But I found a good paper that it's not very new. It's from 2006, but I think it gives us an idea of the proportions and the costs around the litigation and conflict resolution mechanisms. And basically, the paper says that litigation, and I guess this is something we kind of all know, and I'm glad that previous speakers have given a very good legal definitions of what these things are, so I don't have to go through them again. But basically, the message of the paper is that litigation is likely more costly than mediation or other IDR methods, and mediation and arbitration also tend to be more costly than negotiation. And so this paper is based on the US. Again, yes, there's not a lot of data, but there's some data from the US, and they collected data on some of these cases, and the authors come to the conclusion that the mean transactional cost for mediation is around 1.2 million, and arbitration is 1.17 million, and they were much higher than the cost for negotiation, which was estimated $330,000. The median dispute amount was smallest for negotiation, 250,000, and largest for arbitration, 1.8 million, suggesting that very large claims usually go to arbitration and litigation. Smaller disputes have higher transaction cost, 39% of the claim value, compared to bigger disputes, which have 70% of the claim value. This implies that litigation and arbitration, typically used for larger claims, are proportionally cheaper than mediation or negotiation for small claims. Transactional costs represent 2% of the total contract value for projects with disputes. So for example, for a 100 million construction contract, the litigation, if it's 2%, would be more or less equal to $2 million in transaction costs. The paper also estimates that total transaction costs for construction dispute resolutions in the US was around 4 to 12 billion per year. If 5% of disputes go to litigation, also an estimate from the paper, litigation share could be $200 to $600 million. Then the paper also says that it's usually $5 billion spent annually on construction litigation. If we adjust that for inflation for today, we will be talking around $11 billion spent on conflict resolution and litigation. So this is just to highlight that there are a lot of costs and they vary depending on how you choose the dispute mechanisms. Can we go to the next slide, please? And this is important for emerging economies because construction is a major industry in most emerging economies. Some estimates put it at an average of 6.3% of their GDP. And even in countries like China, it's estimated to be up to 15%. Long, costly disputes can derail or delay construction projects, which has a ripple effects across the economy, in job losses, unfinished infrastructure, and reduced economic activity. If disputes arise but aren't resolved quickly and fairly, it creates uncertainty and risk for construction firms and investors, reducing future investments and development. Construction disputes often involve multiple parties, owners, contractors, subcontractors, etc., and weak institutions multiply the economic cost as disputes could drag on. Emerging economies need infrastructure and real estate development to support growing populations and economic expansion, and an effective construction dispute resolution system is critical to enable this sector. Can we go to the next slide, please? And here, just to see why regional disparities in judicial systems disadvantage emerging economies more. So as I mentioned, there's no data, no comprehensive data on construction dispute resolutions worldwide, unfortunately. But what I did is to try to have a proxy on how they would look like using commercial dispute resolution data. So that we have that data, but we don't have a specific for construction, but I guess it's a good proxy to kind of analyze how it differs. So you can see in the blue bar is the average time to solve a commercial dispute. And you see that in some regions like South Asia, Latin America, and the Middle East is much higher than East Asia or high-income economies. So if in East Asia is an average of 485 days, in South Asia is more than double. And then the other bar that you see is just there's an index put together on the quality of judicial process index. It's ranked from 0 to 18 and includes core structural proceeding, case management, core automation, and alternative dispute resolution mechanisms available. So you also can see that economies like the high-income economies in that index, out of 18, they have 12. And then in South Asia, they have 7 out of 18. So you can see that there's a opposite correlation on there's more time for commercial disputes in emerging economies, and they also have a less quality of the judicial process compared to other regions. So this just to highlight that this is an important issue for emerging economies. Can we go to the next slide? The last one too. So to conclude, basically, these are some actions that could be considered for policymakers and emerging economies moving forward. Expand and improve commercial court systems to handle complex construction disputes efficiently, invest in training judges in construction law and industry practices, promote alternative dispute resolution methods like mediation, arbitration that can resolve disputes faster and cheaper than litigation, pass laws to facilitate and enforce arbitration, establish or expand special tribunals, boards, and forums focused especially on construction disputes with experts who understand the technical aspects, make courthouses and legal proceedings more accessible to small businesses and lower income groups through reduced fees, simplified procedures, or greater transparency, increase legal aid and pro bono assistance for construction parties who can afford legal representation through partnerships with bar associations, use technology to streamline dispute resolution processes and make information about the system widely available, online case processing and tracking systems, for example, expand mediation arbitration training programs at universities to build up a qualified pool of legal, construction, and industry experts, increase public legal education so parties understand the rights and options for effective dispute resolutions under the law, and learn from successes in other countries and jurisdictions to adapt best practices to the local context. So I will stop here, and thank you so much for listening to my presentation today.
Thank you, Alejo. I just confirm again that Alejo is a senior private sector specialist at the World Bank, and he's also a board member at the International Building Quality Centre. I found his talk fascinating, and it's really tar on the ground stuff. A key takeout there was that there are more challenges in emerging economies in terms of the judicial infrastructure and the machinery. And I suppose what's very, very sobering is when one gets that takeout, you look at the context where a lot of the population live in a subsistence economy setting. Access to justice is very, very challenging for Main Street, as it were. Thank you so much. And I think it flows nicely into Martin Burns' next topic. Martin is a barrister and head of alternative dispute resolution research and development at the Royal Institute of Chartered Surveyors. And I'm so delighted that he's joined us tonight, because he's right at the cutting edge of best practice ADR. And I know he's passionate about that. So I will hand over to you now, Martin.
Thank you very much, Kim. And yeah, you're absolutely right. I'm passionate. I've spent the last 33 years encouraging people and businesses to try and find better ways and more cost-effective ways of avoiding, managing, and resolving their disputes. Next slide, please. The truth of it is, and you know, this has clearly come across in the talk so far, that construction disputes are bad for the industry globally. At RICS, we've seen that many disputes across the globe are immensely costly. They amount to billions of pounds worth of costs, legal spend, and other costs right across the globe, and the cumulative delays in delivery of projects amounts to, you know, thousands of years right across the globe. So it's a massive problem. One of the things that we've really got our teeth into at RSS over the last few years is the fact that whereas in the UK we have a very sophisticated lot of systems for resolving disputes. We have our own technical construction court for dealing with construction disputes. Adjudication is very popular and widely used. Arbitration is used, mediation is used. We have all these very sophisticated and integral dispute resolution methods within the industry. But what we've come to realize as well is that more work needs to be done to actually stop disputes happening in the first place. And RSCS is a leading body in the UK. We're a professional body. We regulate charter surveyors, but we also work with other organizations. Can I have the next slide, please? What we came to realize some years ago is that there is a need to start working on methods and methodologies for businesses and organizations to be better prepared for disputes. Don't think about disputes after they've happened, after the parties have employed lawyers, after they've spent lots of time and lots of money trying to resolve them internally, or employing lawyers to resolve them, or ending up in court systems. It's much better to think about disputes as something that are in many cases inevitable, and that people need to think about what to do if they happen, and maybe find ways of managing and avoiding them much earlier on. And RSCS has worked together with a number of organizations, and there's a few of the logos here just to demonstrate that. In fact, there's about 40 organizations as part of this coalition, and this coalition is called the Conflict Avoidance Coalition, and it is working to develop methods that would enable businesses and institutions, organizations, and indeed governments as well, to avoid and manage disputes much better than is currently happening. Now, one of those organizations you'll see is the logo there is Transport for London, and I'm just going to very quickly give you an example. Transport for London worked with RSCS a few years ago to develop a conflict avoidance process that was baked into £7 billion worth of contractual works for the refurbishment of the London Underground. And that process was hugely successful, because what it did is, instead of disputes starting to emerge and then crystallize and then develop into long-winded matters that ended up in court or arbitration. They were actually dealt with using a conflict avoidance process in a matter of weeks, saving Transport for London hundreds of thousands of pounds on costs. And I was told at that time by the Deputy Commissioner for the Transport for London that by implementing the conflict avoidance process, a dispute which would normally cost somewhere between 100,000 to £500,000 to resolve was resolved in a matter of weeks at a cost of £12,000. And this process now is of itself being used more widely across the industry, and there are public bodies here who are committing to it. Now, this coalition has come together, and what it decided to do is it needs to find a way to encourage more people to start thinking about avoiding and managing disputes. And someone at our very first meeting came up with a bright idea of a pledge. Next slide, please. Now, I'd like to say it was my idea at that meeting. There was about 12 people around the table, but it wasn't. It was somebody who came up with this idea that if businesses and organizations could be encouraged to sign up to a pledge which committed them to adopting early intervention techniques, to embed conflict avoidance mechanisms into their projects, and identify disputes much earlier than previously is the case, and to implement contractual mechanisms that dealt with those disputes early and quickly, then that of itself would help to reduce the costs to the industry of dispute and delays that would result out of them. Now, there's a little link there, a web link, and I'd encourage you to go onto that, and you'll see how many of these organizations and which organizations have so far signed up to this pledge. Now, we had the benefit when we were putting this pledge together of having some real major industry bodies as an audience. And we thought if we could find a form of words that these bodies would be prepared to sign up to, then we'd have, if you like, the right pitch for the pledge. Next slide, please. And this is the pledge itself. This is the document that's now been circulated. And what we found is that organizations are readily signing up to this and using it as a means to signal to employers and to contractors that they are a good organization to work with, that they believe in collaboration, that they believe and will use methods to identify potential disputes early and to work together with the other parties to try and resolve them, rather than allow them to escalate and get out of control. Next slide, please. Now, it's all right having a pledge, you know, a commitment that somebody just signs, but what we also want to do is to ensure that organizations that sign up to this pledge actually mean what they say, and that they will not just sign a piece of paper and say, we are committed to conflict avoidance, we are committed to working collaboratively with our contracting parties to try and avoid and manage disputes, that we will actually put processes in place. And what we're finding now is that there are businesses, particularly in the UK, who are starting to implement actions which mean that when parties tender for contracts, the first thing they have to do as part of the tendering is to sign the pledge. And then as the contract progresses through to delivery, that through the lifetime of the project, they actually work to not just sign the pledge, but take formal steps to incorporate policies which really give life to their commitments. So put things into the contracts which are early intervention techniques, early warnings, amicable resolution, conflict avoidance procedures, dispute avoidance panels, dispute boards, all the sort of things that would work to help parties to manage and resolve their issues much earlier. And so we've put together a sort of a grading system into a directory so that organizations that sign the pledge will be labeled as bronze or silver or gold, depending on the extent to which they've actually not just signed the pledge, but actually put steps in to implement the commitment that they make by signing up to it. And the goal level, and I'll give you one good example of goal level here in the UK, is the organisation Network Rail, which is responsible for most of the rail network across the UK, which has not just put in place, not just signed the pledge, but have put in place commitments in the contract. It actually does what it says it's going to do, and it works very, very closely with contractors, with supply chain, to manage contracts, to manage projects, to work collaboratively, and thus use methods that help avoid disputes, rather than allow small issues to escalate into larger issues, to escalate into full-blown disputes that could end up in long and costly court action. Next slide, please. The Conflict Avoidance Coalition was formed, it was about 5 years ago, and it has grown from initially 5 or 6 organisations to somewhere in the region of 40 now, and the signatories to the pledge are over 400. It also has caught the eye of the UK government. Now, what I've done with this particular slide is just give an example of how this is now starting to be really taken on board by officialdom here in the UK. Now, the construction playbook is actually government guidance to authorities and organisations that are involved in public works projects. In other words, projects that are paid for out of the taxpayers' account. And in the construction playbook, which was published almost a year ago to today, the government has set out a number of policies, but one of those key policies is on a comply or explain basis, a requirement that anybody involved in public works programs signs the pledge. So what started as a kind of an idea between a number of organisations to try and encourage more organisations to work better to try and manage their disputes has now become effectively government policy. And that government policy is set out in the construction playbook, but it's also engraved elsewhere right across the UK, and we're starting to see interest outside of the UK as well. Next slide, please. Examples of that is the UK Cabinet Office has issued policy notes, which is around responsible behaviour for contracting parties in the construction sector. And in that policy notes, it encourages parties to sign the pledge. So the pledge is now really starting to be ingrained into public policy. The Welsh Government, when it issued its post-COVID recovery plan for the construction industry, the recovery plan set out 12 key points to try and encourage a recovery in the construction sector. And point 4 is sign the pledge. And in the Scottish Government has also issued policy notes, and there's a policy note there that's identified specifically, which encourages, again, businesses and organisations in Scotland to sign up to the pledge. Just a quick interesting anecdote. I was in Scotland just at the time this policy note was published, and there was an audience of about 40 or 50 people there. And I was alongside an official from the Scottish Government. And I was talking about the pledge and encouraging the people in the audience to sign up to it. And these people represented businesses. They were project directors, they were managers of construction companies. And somebody at the back of the audience, in a very broad Scottish accents, asked me, well, why should I sign this pledge? And of course, I'm trying to think on my feet at the point. And at that point, the government official right next to me retorted to this person, why wouldn't you? And I thought that's a great answer, because the pledge itself is a signal that you are committed to try and avoid a dispute, to try and manage it as best you can. And by not signing it, you're probably signaling the complete opposite. And that's the kind of key message that came across there. And that's a very key message, I think. What we're also seeing now, and this is immensely
2
encouraging.
minutes, Martin. 2 minutes, my friend.
Thank you, Kim. Time flies, isn't it? And I think I'm practically
It
there.
does when you're having fun.
What's really encouraging now is that this, which started off as a very UK-centric initiative, is starting to gain real interest. We're talking with officials, government officials and business officials in the Middle East who are also very interested in how to adopt conflict avoidance processes and techniques that are now starting to be ingrained into contracts in the UK. And we're also seeing it in North America and particularly in Canada. We're starting to see real interest, particularly around Ontario, which has a lot of big infrastructure projects. And I think that's me. So thank you very much for listening to that.
Thank you, Martin. I found that very, very interesting. And one thing, key takeout was dispute avoidance. You know, we talk about dispute resolution, but it's best to avoid rather than in a post-mortem capacity, consequential upon not avoiding dispute, being in a situation where you have to resolve it. So that was a very, very interesting take, and I want some general discussion of that in the panel session. Thank you so much. Now, we've got a highlight coming up now. Every speaker's being a highlight, I might add, but it's my great pleasure to welcome Her Honour Francis Kirkham, CBE. Francis participated in the development of the guidelines along with Zama and some other board members and external altruists. Her Honour is a chartered arbitrator, adjudicator and mediator. Her Honour is also past judge of the Technology and Construction Court, England and Wales. And I've mentioned that Her Honour participated in the development of the good practice IBQC guidelines. Her topic is effective management of an international arbitration. Is this possible? Thank you, Your Honour.
Kim, thank you very much. And thank you all very much for very kindly inviting me to participate in this extremely interesting conference. I've really enjoyed listening to all of the previous speakers. Well, as Alejandro has explained to us, an effective and fair dispute resolution process is vital to the development and economic health of a country. Now, in most countries, domestic courts and domestic arbitration will usually provide a service for local disputes. Major construction projects commonly involve the participation of commercial organizations from around the world, from all parts of the world. Now, the companies involved in work of this sort usually demand a method of resolving disputes which does not involve using local courts. So the common method of resolving disputes between parties in such projects is arbitration. And it's usually called international arbitration, as the parties will be from different countries. So in my talk, I'm going to concentrate on international arbitration rather than domestic arbitrations. Now, it would be wonderful if all disputes were avoided, for example, in the way that Martin Burns has just illustrated. But currently that is not happening. And if disputes do arise, then I respectfully support what previous speakers have said about the benefits of mediation. But if settlement cannot be achieved amicably with the help of a mediator, then there will commonly be recourse to arbitration. So this short talk is looking only at arbitration of disputes in major infrastructure projects, for example, those involving the construction, engineering, oil and gas sectors, projects of that sort. Now, the truth is that international arbitration is, in these sectors, is hugely, massively expensive. The cost is a real deterrent. And if a party is unable to afford to pursue a good claim, then that presents a real injustice and one that should be remedied. So I'm going to look very, very briefly, firstly, at ways in which the cost of participating in an international arbitration might be controlled. Secondly, at how arbitral institutions could, and in my submission, should help. And then finally, at the role that states and local domestic courts really must play to help take matters forward. So I'll begin with the tribunal and the parties. Both are responsible for trying to control costs. And I ask myself, well, why might they not feel able to do this, or perhaps may not want to do this? So let's take the tribunal first. And the tribunal is primarily responsible for running a process which is fair, cost-effective, and is concluded as quickly as is reasonably possible. But it's not uncommon for arbitrators to lack the confidence to do that. Many arbitrators feel unable in the international context to exercise the powers which they do have. There are a number of reasons for this, but one reason which is very often present is that if arbitrators have taken a robust approach to managing the arbitration, they may well be worried that the losing party might be able to persuade the relevant local court just not to enforce the award. And in some parts of the world, local courts are indeed looking for reasons, however spurious, to prevent a winning party enforcing a good award. And this might arise, for example, because the tribunal might have refused a party request to make a last-minute major change to its case, or it might have refused a party permission to introduce new documents or evidence at a very late stage. Our tribunal decisions of that sort may, in the context, be entirely fair and legitimate and proper, reflecting the tribunal's duty to run a fair process. But it's not difficult for a hostile court on an application for enforcement to conclude that an order of that sort was unfair and decide that enforcement should be denied. We'll next look at the responsibility of the parties and how parties in fact behave. And in disputes where large sums of money are at stake, parties will usually be represented by lawyers. The legal teams will often comprise very large numbers of people. The fees and expenses which law firms incur in international arbitrations can be very substantial indeed, to the extent that parties find themselves simply unable to afford legal representation. In part, this is because in many parts of the world, legal fees are high in any event. But it also represents the fact that lawyers are defensive. And one illustration of this is if the lawyers produce every single document which has ever been created and which has any connection, however tenuous, with the project in question, their client will not be able to complain that the lawyers failed to produce a document to the tribunal. That sort of defensive attitude leads to what is often an absurd overload of documents, thousands of pages, which in the end are never even looked at in the arbitration. So what can be done? I suggest that the main responsibility lies with the tribunal. we've had useful discussion about the benefits of mediation. It seems to me that an important task for the tribunal is to talk to the parties about mediation, if necessary, to explain to the parties and their representatives what mediation is, how it works, and to make the point very forcefully that mediation is a process which can happen at any time during the course of the arbitration. And the tribunal should always be encouraging the parties to make time for constructive settlement discussions. Tribunals must, of course, operate within the rules and regulations which govern that particular arbitration. But most sets of rules will give the tribunal wide powers to provide robust and fair case management. And of course, the process must be fair, but fairness doesn't mean that a tribunal must necessarily approve and implement a protracted timetable of procedural steps which the parties might jointly propose. The longer an arbitration takes, the higher the overall cost will be. And a fair process is one in which the tribunal provides its award, its decision on matters in dispute, expeditiously and at minimum cost, whilst giving both sides a fair opportunity to put their cases. In terms of how a tribunal can go about this, there are various tools at their disposal, including looking very carefully at whether an early issue can be taken. Taking an early issue for determination can very often lead the parties subsequently to settle the remainder of the dispute and other steps which are available. I think that these should be left as a topic for another talk. There isn't time tonight. Now, whilst these matters are, I think, primarily the responsibility of the tribunal, party representatives also have an obligation to work cooperatively with the tribunal. Now, the rules and regulations under which some international arbitrations are conducted do require the parties to cooperate with the tribunal, but some are silent on the point. Now, that, I would suggest, doesn't mean that parties are free to fail to cooperate or feel free indeed to misbehave, though sadly some do. And that leads me to my next point, which is the role which arbitral institutions, the umbrella organizations, have to play in this. It seems to me that there is scope for the various arbitral institutions to include in their rules and regulations a rule requiring party cooperation, and to include rules which allow the tribunal to impose sanctions for failure by parties to comply with orders which the tribunal might make. I should also like to see the umbrella arbitral institutions introduce express powers to arbitrators to order one party to pay the costs of another in relation to discrete matters during the course of the arbitration. That is, adopting the pay-as-you-go approach, which has been very effective, a very effective tool in case management in the domestic courts in England and Wales. So I referred to some of the factors which can prevent a tribunal managing a case robustly. And there is one further point which I would make, which applies in some jurisdictions, and that is the difficult question of immunity from suit. If tribunal members are conducting an arbitration in a jurisdiction in which they do not have immunity from suit, then they are likely to feel that they are personally at risk unless they adopt a very defensive approach to managing the arbitration. And there are jurisdictions in which arbitrators have good reason to fear the actions of a state which just does not like the tribunal's decision. And that leads me to my last point, which is I would suggest that it's vital that countries accept the concept of arbitrator immunity and offer genuine support to the arbitration process. If they do, their country will find that excellent arbitrators are willing to accept appointment, and the parties will have the benefit of good awards. But also will have the result that commercial organizations considering embarking on major projects in that region, in that particular country, will have more confidence. So in short, if there's no arbitrator immunity, good arbitrators may decide not to accept appointment. Local courts must be supportive of a tribunal which has acted properly. If a commercial organization fears that an award in its favor may not be enforced by the local court, it may decide just not to undertake the project at all, or at the very least, it will increase its price to reflect the risks that it will be running. So the consequence is that failure by a state to ensure a fair and robust environment for tribunals and parties to arbitration can result in increased project cost and the refusal by good arbitrators to participate. So in summary, Kim, I would suggest that a fair and effective process at proportionate cost is possible in international arbitration, provided arbitrators have the confidence to act robustly and parties cooperate with them. And states need to be aware of the need to provide an environment in which arbitrators are supported and can operate safely and effectively. Thank you.
Thank you very much, Your Honour. Now, we've got 15 minutes to go, and I think we'll tie some of the threads together. If you could all possibly come back onto video screen and unmute yourself, that'd be wonderful, because I think we can have a bit of an interactive discussion. So just reiterating, if you could all kindly come back on screen. Now, the first thing I'll say is this has been a two-part series, Northern and Southern Hemisphere. There've been about 19 speeches. Everything's been recorded and the papers will be available on the website. So it's to be looked at as a totality. A couple of things that came through last night were critical importance of front-end mediation, compulsory front-end mediation. It was also noted in the paper that I presented that we do have a huge problem with the cost of construction dispute resolution globally. Claims and advisory dispute resolution experts, HKA, investigated claims and disputes on 1,600 projects in 100 countries in 2022. The combined value of the projects investigated exceeded 2 trillion, roughly 1.7 trillion. Total claims analysed in the report exceeded 80 billion in value, with cumulative overruns adding up to 840 years. In terms of a synopsis of what I submitted, has been less than optimum construction dispute resolution systems. Three key things: they work against utilitarian outcomes for parties embroiled in legal proceedings, by and large destroy commercial relationships and contracting relationships per se, and they lead to divergent rather than convergent outcomes. In many jurisdictions, there's a history where adversarialism is part of the dispute resolution modus operandi. That is divergent dispute resolution. Convergent dispute resolution is about engineering an accord. Martin has mentioned today that let's move away from the assumption that there will be dispute resolution. Let's look at a scenario where disputes are avoided in the first place, and the putting into place mechanisms and stopgaps where there can be interventions that prevent the dispute. He made mention of the pledge, and I think that is, in the IBQC, we're interested in world's best practice. To me, that sits well. Alessio had some very, very interesting takeouts, and it was so important to get a World Bank economist's perspective. I know it's his personal views, but he said emerging economies are particularly bludgeoned by the inefficiencies or lack of access to judicial infrastructure. We've heard about the virtues of arbitration. Zama gave an interesting perspective in terms of South Africa. She made a very, very good point. Arbitration does have its place. Personally, I think in a jurisdiction that doesn't have advanced judicial infrastructure, arbitration is critical, particularly with regards to PPPs, where you can get an offshore arbitrator to resolve a matter where there mightn't be local expertise. But Zama made this very, very interesting point, namely that arbitrated decisions do not contribute to the body of law and precedent. And yet many arbitrated decisions could well have a wonderful body of law. And I just wonder if in the fullness of time, there could be a move where arbitrated decisions in certain jurisdictions can be published so that they can be woven into the fabric of precedent. So we've had a very fertile couple of days. I thank you all so much for, number one, attending, number two, giving of your time, number three, producing very erudite reports. Now, there aren't any questions coming through from chat forum, but I invite the panel to just stream of consciousness for the next 10 minutes. Be forthcoming in anything that they just want to make mention of.
If I may, Kim, maybe this might be outside the area I was discussing, but I think the point on PPPs and countries, I think it's fascinating because I also work with on foreign direct investment regulations for developing economies, and I feel that we see a lot of these bilateral investment treaties now that do have a lot of clauses and a lot of material on dispute mechanisms, because again, as I mentioned, we know that sometimes usually the judicial system in many development economies are not functioning properly. And I think this is also it's a big discussion, it's a big debate. I think it makes that alternative dispute mechanisms like arbitration are even more, as I was trying to say, more important than in jurisdictions where you have a more developed judicial system. Maybe you don't have to choose one another. Maybe you have to strengthen your judicial system anyway. You don't have to leave it there. You should do reforms to also strengthen it. But in the meantime, I guess having these dispute mechanisms is key because, for example, in PPPs, a lot of developing economies are talking about we need more investments in our infrastructure and they want to bring foreign investors. But if you don't have this type of dispute mechanisms, it's very hard that an investor will go and will venture itself to try to dispute any or go to court in any potential disputes at the local level. So I think this is central not only for this forum, which is very important, but also in the bigger picture for emerging economies. Having these alternative dispute mechanisms are key for investors to bring capital that is much needed in these countries. Thank you.
Thank you, and that's a really important macro point you've mentioned, Alessio, and that's why I mentioned the example of PPPs, where there is going to be a collaboration between government and major it might be NGOs, industry players, to capacitate an economy. There must be confidence that there is sophisticated judicial infrastructure. And if there isn't an arbitration mechanism to ensure that disputes can be resolved and a PPP just doesn't fall apart. And I'm glad you hammered home that point. Now, there is one of our friends who has attended both conferences is federal court judge Madot from Ethiopia, and she has asked a couple of questions, and I'll just bring them up. Question of Rachel. This, as I say, this is from federal court judge Madot. How do you assess arbitration being as an effective dispute resolution mechanism in cases where there's a class action or a joinder of parties and different stakeholders? So typically in a garden variety of dispute, in Australia, you might have architect, building surveyor, local government, builder, all implicated in a set of proceedings. Whereas where there's an arbitration agreement, the arbitration limits the ambit of the claimants to owner and to property owner and builder. So the question is, how does one approach the joinder issue in arbitration proceedings?
Well, obviously that varies based on which set of arbitral rules you're proceeding under, but as a general rule in the United States, you would have a class action waiver if you're in an arbitration. Class action are under federal law, you would go, or under state law, they would proceed in the courts. It goes to the point I made about the bringing of so-called mass arbitrations. There aren't actually class actions in the arbitration proceedings, but sometimes plaintiffs have been just filing in well, they're numerous, but sometimes they feel innumerable simultaneous individual arbitrations as though they were class actions to try to get around the class action waiver to which they had previously agreed. But I think that's more generally in a tort context. In the construction dispute area, I think probably the more relevant point would be whether you can do joinder of defendants. And I understand from Kim that may not actually be possible in Australia. I think that's what he said in one of our prior conversations. Whereas under most of the rules here, that's fine. We have co-defendants in arbitration all the time, or in one particular matter that I'm pursuing now, I have sued multiple individuals who are co-defendants, and you can have joinder of defendants in arbitration in the US.
Okay, just on that note, you might be interested, Rachel and Your Honor, there was discussion last night about arbitration being a good dispute resolution vehicle for higher dollar value disputes, but not necessarily for, let's say, residential settings where you've got a dispute between an owner and a builder. And you might be interested to know anecdotally, in the mid-90s in the state of Victoria, there is a legislation that regulates building contracts, and there's a dedicated dispute resolution division in the VCAT, Victorian Civil Administrative Tribunal. But in the mid-90s, they made, in terms of residential dispute resolution in the whole state, the use of arbitration clauses illegal. So arbitration in the state of Victoria is exclusively for civil and commercial disputes. So I just thought I'd make mention of that. Now, a second question from Judge Madot is, and this is for Justice Gloria. My first question for Your Honor from Malawi: what standards do you use in dealing with controversial issues that may arise in balancing the interests of parties with regards to rendering interim measures like injunction when public interests are involved? And what are the standards you consider in defining public interest, Your Honor?
Thank you very much.
And we've got 3 minutes to go. Yes.
All right, I will quickly answer the question. I think the rules that I talked about, the high court rules, they have standards there where we have to examine whether you are going to grant an interim relief or not. So obviously, you'll be looking at issues like whether the claim that is before you is raising triable issues that can go for trial. I think they're the same guidelines that the judge will look at whether to grant an injunction or not, whether damages will be adequate, and then if the other party would demonstrate capability or capacity to pay the damages in the event it is discovered that the injunction was wrongly granted. And then we also look at the balance of convenience. The rules are calling it whether it's going to be just or unjust. So we'll be guided by those ones. Now to come to the issue of whether we have any standards in determining what is the public interest. I think we'll be looking at issues like, is it hinging on a policy that is affecting or that will have an impact on the majority of Malawians, especially the poor or the marginalized? So as I said, maybe because the judge will have has been given very wide discretionary powers, so it always depends on the circumstances of the facts that are before you. So those are what we'll be juggling with in coming with a decision whether to grant or not to grant the injunction. Thank you very much.
Okay, now there are a couple of more questions, but I'm going to have to wind up now before we go offline. Just one thing I noted also, Her Honour Francis Kirkham's comment about the critical importance of immunities for arbitration. That's just axiomatic, and it should be facilitated by legislation in the particular arbitration instrument, best served by legislation. Now, you may ask where from here. The IBQC will be publishing all of the papers, and the recordings will be available on the IBQC website. I think this collection of individuals that we've had over the last two days has brought to bear a concentration of some of the best thinking on the planet and best innovative thinking on the planet in terms of how to cut the cost of dispute resolution and make justice more accessible to Main Street. It really is international best practice thinking on point. This conference has been about 18 months in the making. It's taken a long time, and thank you for your patience. Thank you for your participation. And I hope to be in touch with all of you very near future, individually. And the IBQC expresses a great debt of gratitude to you all, and that applies to both days. So have a wonderful day or a wonderful night. It's now 4 a.m. in the morning in Melbourne. And our little girl, we said she won't go into school in the morning because Sigetta and I are quite tired. So thank you so much. Wonderful evening, morning.
Thank you. Good morning. Good morning. Good evening. Bye-bye.